Sorry, guys. Everybody's busted out back. Sorry.
I'd be tempted to sustain for the first couple of months.
Where are we?
Okay, it's like we can.
All right, everybody's here. It's a little after. All right. Good afternoon, everyone. First, let me announce all the decisions of this board are considered final. If there's anyone aggrieved by the decision of this board, may appeal circuit court within 15 days of the board's decision. Also, no permits or license can be issued until that 15-day appeal period has expired. For information regarding the board's decision or an appeal circuit court, the Office of Land Use Administration will be your contact. As you come to the podium, address the board, not anyone in the audience or anyone with the staff. And I'll ask at this time if you've got an electronic device, you turn it off or silent so we don't have a disruption. There's a 5-minute limitation for speakers, normally 4 in favor of an application, 4 in opposition, and we'll be considerate of that. And we'll now have the roll call. Mr. Davis.
Here.
Mr. Coleman.
Here.
Mr. Metcalf.
Here.
Mr. Burrows.
Here.
Mr. Milling.
Here.
Mr. Golden.
Here.
And I'm William Guest. We have 7 members present. It takes 5 to affirm a motion. We have a quorum, and I'm unaware of anyone recusing themselves from any of the applications at this time. Mr. Anderson's our attorney for majority of the applications. I think one he'll recuse himself, and Mr. Minus will be sitting in for that one. And we'll go in order. We've got a couple of holdovers. We'll start with the first one, application 6210, Rainbow Signs.
Mr. Guest?
Yes.
The applicant indicated to staff that they were no longer interested in pursuing the application. However, they would not formally withdraw.
Okay. Do we have anyone in the audience that was here either favor or opposition to this application? Okay, waiting for the record. For the board, the staff recommended for denial, and as Ms. Pappas said, the applicant has declined to attend. So hearing none, I'll request a motion from the board. Okay, what is your motion, sir?
To deny.
Okay, a motion to deny. Do I have a second? Second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, motion carried. Okay, we'll go to the next holdover, which is 66224. Mr. Myers, 2955, 989 Dolphin Street.
Good afternoon. I'm Casey Pipes at Helmsing Leach for the applicant, Rob Myers.
Your address, sir.
2255 Ashland Place.
All right, thank you.
Thank you. Sorry, Mr. Chairman. We were here a month ago on the application. One was an administrative appeal that the board didn't rule on. The other one is the variance request that was held over. I believe, everybody said a lot of things about both issues last time. We're here for a ruling. I'm available to answer any questions, but the short answer is we're asking for a variance as an alternative remedy to the administrative appeal to allow the car wash, which was a use that was previously approved by the city before Mr. Myers purchased this property as a PUD. That PUD expired. He went back with a similar PUD request, avoided hitting some trees, and that's when this came up that there was a new interpretation that the zoning didn't allow for anything other than a drug store or bank at this lot, which is not what the text of the ordinance says and was not what the Planning Commission or anybody at the city told Mr. Myers before he bought the property, which presents an opportunity for this board to give a variance to avoid the hardship that Rob would suffer for buying this property in reliance on the previous approvals by the city, which is a different kind of variance than y'all usually see, but a valid reason for a variance under Alabama law to grant the variance to avoid the substantial hardship that is different in kind and nature than the rest of the public, and that is based on the misrepresentation, if it was a misrepresentation by the city of what the zoning code would allow. Primarily, we believe the ordinance allows for any B2 use on the site, and that's the basis of the administrative appeal that was also filed on the last month's agenda, but not on this month's agenda.
Any questions for the applicant's rep? And this is probably more for our legal advisor. You gave us an initial review of kind of the history of this property and such. The basic question I have is it zoned R1 or B2 at this time, based on the PUD expiring?
It's my belief that it's still zoned B2, but the as indicated in my opinion, that the I don't think that matters for purposes of the variance request, because the review of whether the variance should be granted or not are the same under either designation.
Okay, so there was no condition with the PUD that it would revert back to R1 should the PUD not be followed through or developed?
That's my understanding. It didn't revert back to R1. Now, I know some of the property owners that have opposed this request. That's their position, that it did revert back to R1.
Right, and it's your position that it was a condition of the PUD that was originally approved?
Correct.
For it to have,
and that any new request would require a new PUD to accompany that, but that it is limited to the use of a bank or drugstore.
okay. Sir, based on that, did you, or as the applicant's rep, they applied for another PUD, correct? Back after the first one expired?
Correct, Your Honor. You're correct, Mr. Chairman.
And that was denied?
Yes.
Okay. So the normal process for the Planning Commission would be the City Council, an appeal of theirs, correct?
Correct.
And then the Circuit Court, or from a legal standpoint, correct?
Correct. The disconnect was that the reason the Planning Commission The expressed reason the Planning Commission denied it is because they didn't find that the use was an allowed use. A car wash wasn't a permitted use, which is not had anything to do with the driveway or the roads going in, which was the whole point of the PUD.
My question is the process that you followed so far.
The process is as you described it, but there's also a what's the permitted use on this property process. And that decision does not go through the Planning Commission. It goes through the zoning official at the city, where we got a letter saying what the zoning was. The first time we ever heard about it was after the Planning Commission process. Then the appeal comes to this board and the alternative variance request. If it were granted, I completely agree with Mr. Minus. If this board were to grant our variance or the appeal, we would have to go to the Planning Commission to get a PUD approved before we could build on it. We understand that. But this board can tell the Planning Commission what the uses are allowed. And people come to get a variance all the time and then have to go back and get their PUD, or you can't get your PUD approved until you get this variance or this use allowed by this board. These things work all the time in this order. We didn't know about the problem or the position the city was going to take about the use until we were literally standing here at the podium at the Planning Commission. It didn't come out in the staff report, didn't come out, along the way. It was at the hearing. So we didn't have time to back up, come to y'all, and then go back.
Okay. Anything to add, Mr. Minus?
I think it's been stated before, but I believe the property remedy at the time of the city affirmed the Planning Board's commission would have been to appeal to circuit court. That particular decision, the parties entitled to request a variance as we are here without having to go through that process. And that, if you'll recall at the last meeting, we determined there wasn't a decision by the city as to the use other than the city council's affirmation of the Planning Commission's decision would give jurisdiction to redecide or reopen that issue.
When they PUD, and I'm not real clear on the PUD and the Planning Commission's authority, can they, my understanding, they can put a condition on a piece of property as per the development, correct?
Yes.
So that could have been, that appears to have been a condition originally that was conditional on that development.
But that wasn't the issue, and I think Mr. Pipes has reiterated they know they have to go back and ask for a PUD if they went through that process. But we didn't get to that process, and I didn't believe there was jurisdiction for us to decide the prior request, other than the variance.
I'm just asking about the normal process for a PUD. A condition can be put on it to be specific. I just want to make sure I'm clear on how the Planning Commission, that initially there was a requirement that it could either be a bank or a pharmacy.
In the review for the 2018 PUD, that came out that the initial rezoning of the property back in 2008, due to the notices, the B2 was conditioned to a bank or a drugstore. But that came out in the 2018 PUD review. If you'll look on roughly page 2, the bottom of page 2 and the top of page 3 of the staff report, you had the initial rezoning application in 2008 for the overall site, and where these two properties in orange were rezoned to B2 based on the revised application notices. It was for a bank and drugstore. When the rezoning was recommended for approval by the Planning Commission and then affirmed by the City Council, an approved PUD was a condition placed on that rezoning ordinance to B2. The PUD expired. PUDs are valid for 1 year. They can be extended, granted an extension. That 2008 PUD expired. It came back up for this site in 2016, and as Mr. Pipes indicated, that was approved. However, permits were not obtained within a year, an extension was not filed, so that PUD expired. It was submitted again in 2018. During the course of review, there was a question by one of the Planning Commission members, and in conducting additional research, the notice and the stipulation for a bank and drugstore was found. Legal opinion was issued to the commission, and based on that, the commission denied the PUD. That denial of the PUD was appealed to the City Council, who affirmed the Planning Commission's actions. That PUD could have been appealed to Circuit Court, as was discussed earlier.
Right.
But now we have a use variance request for the board.
I was asking primarily clarification on what the Planning Commission's authority, if they could conditionally approve, and you clarified that.
Okay.
All right, thank you. Any questions of the board once again? All right.
Thank you.
If you have a seat, sir, I appreciate it. Many of you were here last time and had the opportunity to speak. We'll allow 4 again this time. And this is for in opposition, understand, correct? Okay.
My name is Donald Stewart. I live at 121 Fraser Court. I'm here as the attorney for about 30 people, many of whom are here. If you show your hands so they can see you. We're still here, and we're going to be here as long as it takes. The issue, and it's a convoluted situation, and the history is, bewildering as to how all the things that happened that didn't happen. But you have to bore down on what is before you today, and that is a request for a use variance. It's a given. He cannot put his car wash on this property as it is currently zoned. The debate as to whether it's B2 limited to a bank or whether it's R1, which is our position, is written to one side. Whatever it is, he cannot put, by right, the car wash on the site. What he is asking for is permission under the use variance provision to have you tell him it is now a permitted use to put the car wash there. In order to get there, the law says he has to show unnecessary hardship. He has to show that there are conditions unique to his property that let you get to the legal conclusion that he can get a use variance. He has not presented any facts to you about this use variance other than to explain what he thinks the problem is. The problem is he, and apparently in good faith, and I'm not going to get into that issue at all, he bought this property for about $650,000 thinking he could put a car wash in there. He was mistaken, and it is now fallen out. He can't put the car wash there. What he wants you to do is rezone this thing basically on a spot basis so that he will not lose the benefit of the money he says, with no proof, that he can't sell this to a bank to go in if it's B2 with a bank. He says, with no proof, that he can't put a residential use on there. To get to the discussion of a use variance, he has got to put facts before you, and he hasn't got any facts. He's just making the argument to you that that's the case. But beyond that, the law is very plain that economic loss is not a basis for use variance, and we cite in our papers, and if you go back to the file, you'll see our letter. The Court of Civil Appeals, it says the fact that the applicant might be able to make a greater profit by using his property for commercial purposes is not sufficient to constitute unnecessary hardship. He is in a box. He is clearly in a box. Y'all cannot, as a legal matter, give him what he needs to put that car wash in. What he has to do is start over again to get the property rezoned. He has to go back to the Planning Commission, then through the City Council, to get to a point where he can get to the use that he needs. The circumstances under which he bought the property are between him and the City of Mobile, but you cannot solve the City of Mobile's problem by giving him an illegal use variance. It just doesn't work that way.
Any questions for the applicant? for the residents representative.
I have a question, Mr. Chairman,
Mr. Burke.
and probably to the staff. Has the property ever been zoned in an R category of any type
Prior to 2008,
prior to 2000?
yes, 2008.
When was it? Was it ever codified that through some legal process that changed that?
No, sir. When the current zoning ordinance went into effect in 1967, it was zoned R1, single-family residential. In 2008, this lot was rezoned to B2. Those are the only two rezonings associated with this site.
Any further questions? All right, thank you, sir. We have time for 3 others. Anyone else want to add? Okay. All right, well, we appreciate your time again, coming once again down here. Sir, do you have anything you want to say in response?
Just very, very briefly.
I appreciate that.
Economic hardship can be a basis for a variance. This isn't about us making it the most profitable use, but the use to which we were reasonably relying on when we bought it based on the previous approvals. There are 6 cases from the Alabama Supreme Court that talk about granting variances in a situation where somebody has relied to their detriment on either a permit or an approval that was issued by the city and then taken away after that owner relied on them. There's plenty of law on that authority. And I think it's pretty basic to hear Mr. Stewart say that I haven't offered proof that my client couldn't sell this lot as a residential lot. Everybody here knows that we couldn't sell this lot for what we have in it for a residential use. We can't use it for the use to which we bought it. That is our hardship. We don't have to prove that nobody wants it or that we can't sell it for $5,000 to somebody in order to be entitled to variance. If that was the case, y'all would never have anything here because nobody would ever be entitled to any variances. Entitled to ask for this variance to give this board one last chance to try to fix the situation before it goes down the path that Donald Stewart so wishes that it will through the court system. But thank you for your time.
Okay, thank you. All right, discussion of the board, comments? Everyone's quite quiet today. All right, Chair, entertain a motion.
Mr. Chairman,
Yes.
when you asked if I had any questions, I have a multitude of questions, but every time I ask them in my head, I realize that this is not the place to ask them. And I agree with Mr. Stewart that Mr. Mears is in a box. He's in an untenable situation, and I sympathize with him. And I think that he is no lawyer, but I think he's probably due some relief of some sort or some clarification. And as much as I'd like for him to maybe get that, I don't think it's our place to do so. And I'd made the motion at the previous meeting to have Mr. Minus render us a complete opinion, which he did so, and did so well. And based upon his recommendation to us and the other information that's been given us, recommend for denial.
Second.
Okay, I have a motion with a second.
Second.
Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, motion carries. Thank you all. And thank you, Mr. Minus, for your time. And Mr. Anderson? Yep, he's over there. Okay, we're going to give everyone a minute or two to exit, and then we'll continue. Hey, Lisa, I would suggest you have the minutes for this meeting typed up fairly quick. I would suggest you type up the minutes, or whoever. for today? Yeah. I'm sure they'll be requested fairly soon. All right. For the sake of time. All right, we're going to continue. We have application 6231-286, Broad Street Restoration Society.
My name is Ben Cummings with Cummings Architecture at 1 Houston Street. I'm the architect for the applicant.
Well, let me ask you this. Have you, as the applicant's rep, have you seen the staff's recommendations?
Yes, and I fully agree with and accept the staff recommendations, but I've got one amendment.
Okay.
And I've talked to the staff, and I have sent the staff a revised drawing, and I brought some paper copies that we could pass out today that show this amendment. And the reason for the amendment is last month, I think it was last month, we went before the Planning Commission, one-lot subdivision, and the approval of the one-lot subdivision was instead of a 25-foot building setback line on both Broad Street and New Jersey Street, that reduced to 0. So on our subdivision plat, we will have a 0 building setback line shown. After that approval, we kind of rethought the site plan. The building already encroaches on the building setback on New Jersey Street. It's right up on the property line, and on Broad Street, the existing building is like 13.5 feet from Broad Street. So the revised drawing that y'all are about to receive, it's a floor plan and a site plan. The revised drawing shows constructing an addition to the front of the building that would be built all the way up to Broad Street. So we would have the building on Broad Street up to the sidewalk, and as it is currently on New Jersey Street, it will remain all the way up to the sidewalk. And this is very similar to to many other structures that are in that area, where I think the Con store, across Broad Street, it's built right up to the front and side property lines, and it's on the I guess the western corner, of that intersection. We still have more parking than what the minimum requires, and our overall landscape area meets the city ordinance, but we don't meet our frontage, but we didn't meet the frontage in the current drawing, the drawing that was originally submitted with the application. But we're very close.
Okay, for staff, does this meet some of the conditions? Yes.
When we did speak to Mr. Cummings and reviewed the reduction in the setback along Broad Street should be okay based on how the variance request was advertised. We did consult Mr. Anderson about this as well, and he confirmed that. So the change in plan as proposed should be okay as the variance was advertised.
Okay. And regarding your amendment, the condition is on the 25-foot setback line, right?
That is correct, yeah.
Okay.
That's the only change in this these drawings that you got was building that addition to the
And
Broad
as you
Street.
stated, you're in agreement with all their other conditions.
That is correct.
Requirements. Okay. Any questions of the board? By the way, Mr. Metcalf has recused himself on this particular application. Remaining 6 allows us a quorum to continue.
Mr. Chairman, I have a question. Will there,
Yes.
will there be gates on the entries?
Say it
Will there
again?
be any gating on the entry?
I still can't hear
Will there
you.
be a gate on the driveway?
Oh, a gate. The current design is just a decorative fence. So I presently don't have a gate in the design. That brings up, issues with the stacking of the cars that, so it's a decorative fence, but no gate on Broad Street.
Okay, thanks.
Any further questions? Okay. All right, either of you in the audience here in favor or opposition to this application? Okay, do you have anything to add? No? Okay. All right, the applicant has stated that they're in agreement with the staff's recommendation for approval, subject to the conditions. Any further discussion? Chair, entertain a motion.
Mr. Chair, make a motion that we approve, including the amendment from Mr. Cummings.
Okay, I have a motion to approve to include the amendment. Do I have a second?
Second.
Second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, motion carries. Thank you all.
Thank you very much.
All right, we're on application 6232, PH Building and Design.
Mr. Chairman, we were contacted earlier today by the representative stating that he had another meeting that he had to attend and wouldn't be able to make today's meeting. And I mentioned that the board has historically either held over for one meeting an application or denied on the spot. So just wanted to make you aware that he would not be able to attend.
Right, and I'll concur that we have held over usually if there's some circumstance that the applicant, and they did make contact with you, that they were unable to attend for a particular reason. Unless the board has an opposition, I'll make a motion that we hold it over for 30 days till the next meeting.
Second.
I have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Aye. Anyone opposed? Okay, the motion carries. All right, what is our time? We're doing real good on time, aren't we? Normally in January, based on staff's reminder, I guess, the best way to put it, we're due to elect the chair and the vice chair. And to stay on schedule, I think, based on our time today, I think we can proceed with that. All right, so we'll start with the vice chair. Somebody would like to make a motion for someone to serve as vice chair. I would appreciate it.
Mr. Chair, I move that Mr. Sanford be
Okay, Mr. Davis, I have a motion to nominate
Yes.
Mr. Davis as vice chair. Do I have a second?
Second.
Second. Any further discussion? All those in favor of that motion say aye.
Aye.
Anyone opposed? Okay. And chair. I'll entertain a motion for somebody to serve as chair.
Mr. Chairman, I'd like to motion that our chairman presently would continue to serve as our chairman.
Okay, I have a motion to approve William Guest as chair.
Second.
Do I have a second? Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, I have 5 to affirm, 1 opposed, and I'll recuse myself. So the motion carries. All right, any further business? All right, that will conclude our meeting. Everyone have a good day.
Just like to say congratulations.
Oh, yeah.
Or thank you. Thank you.
Thank you,
And
sir.
congratulations.
Yes, sir. Congratulations. All right. Thank you.
You have a good afternoon.
Yes, sir. You too. Thank you, man.
Thank you.
Thank you. I'll be in touch.
Appreciate it.
Yes,
Thank
sir.
you.
I'll be in touch.
That's why you can